You're charged with a terroristic threat of a public servant or placing the public in fear of serious bodily injury.
This defendant is in court today facing a terroristic threat charge, and this is not something you brush off lightly. He's looking at anywhere from 2 to 10 years in prison, depending on how this hearing plays out. One wrong move here, one bad decision, and his entire future could change in an instant. What makes this case even messier is where it all started, a toxic custody battle with his ex-wife. And if you've ever watched family court turn into criminal court, you already know how dangerous that overlap can be. Emotions run high, accusations escalate fast, and suddenly what started as a civil dispute turns into a felony charge with real prison time attached. That on top of that, this defendant isn't just dealing with one case. He's got a civil custody case running at the exact same time as this criminal case, which means every word said here could ripple into the family court side as well. His parental rights, his freedom, and his credibility are all on the line in the same moment. The stakes honestly could not be higher. AT first, Judge Boyd approaches this like any standard hearing. She's calmly reviewing the plea paperwork, going line by line. Nothing dramatic. The courtroom feels routine, almost deceptively normal. But then she notices something in the protective order that immediately stops her in her tracks. And you can actually see the shift happen in real time. Her tone changes. Her posture changes. The questions get sharper. It's one of those moments where you realize the judge just uncovered something that puts this entire case in a much more serious light. Whatever was written in that order clearly raised red flags, because from that moment on, this was no longer a routine hearing. This is why Judge Boyd is so interesting to watch. She doesn't rush. She doesn't overreact. But when something matters, she locks in, and you can feel the weight of the courtroom change instantly. Let me know what you guys think about Judge Boyd's style. Do you like judges who stay calm until it's time to get serious? Or do you prefer a more aggressive approach from the start? Drop your thoughts in the comments. All right, let's dive in and see how this unfolds.
Charles W. Booker for the accused. Ronald Allen.
All right. Counsel, you received all discovery?
Yes, I did, Judge.
All right, you're charged with a terroristic threat of a public servant or placing the public in fear of serious bodily injury as a third-degree felony. Range of punishment is anywhere from 2 to 10 years in prison and up to the $10,000 fine. If you have a plea with the state, the court does not have to follow your plea. Did you intend to give up those rights and enter into a plea in this case?
I did.
Did you understand that the court were to grant your application for deferred adjudication? If for any reason your deferred adjudication were revoked, the court could find you guilty and sentence you up to 10 years in the prison and up to a $10,000 fine.
I understand.
Do you believe he has a rational as well as a factual understanding of the charges against him?
I do, Judge.
Do you believe he's currently competent and was legally sane at the time of the offense?
I do.
Mr. Allen, has anyone threatened you, coerced you, or placed you in fear to get you to enter the plea?
No.
Anyone promised you anything other than the plea?
No.
Are you a U.S. citizen? I'm sorry, not a U.S. citizen. That's not allowed to be asked anymore. Did you understand by entering in this plea, you could, if you're not a citizen, you could be deported, not allowed to re-enter the United States or denied naturalization? Did you understand?
I do.
Did you review the plea bargain page with your attorney? Did you understand it?
I did.
According to the plea, punishment is to be assessed at 3 years in the prison. There's a $2,000 fine. State is silent on your application for deferred adjudication. The state recommends community supervision. Did you understand that to be the plea?
I do.
Defense?
Yes, that's true.
State?
Yes, Your Honor.
Outside the agreement, the state is recommending that your community supervision be for a term of 5 years. There'll be a TAP evaluation, 200 hours community service restitution, no contact with Charles Ireland or Mark Metley. Did you understand those are recommendations from the state and the court does not have to follow those recommendations?
I understand.
Then to the offenses charged, how do you plead? Guilty, not guilty, or no contest?
No contest.
State, any evidence?
Yes, Your Honor. State tenders what has been marked States Exhibit 1 and all attachments.
Court will accept into evidence States Exhibits 1 and attachments. Court will find there is sufficient evidence to find you guilty. The court will defer finding of guilt as you apply for deferred adjudication. Are you proceeding with sentencing?
Yes, Judge.
All right, anything you wish to say on behalf of your client?
Yes, Judge. Last night, I electronically filed a sentencing memorandum. I think it's been accepted by the court, and I wanted to provide it to you along with the attachments.
All right, any objections to the court reviewing? Okay. All right, yes.
And so, Judge, as you can see, essentially what primary reason and the desire for Mr. Allen is that he be able to continue with supervised access to his son, Aiden. As you can see in the attachments there, the civil trial court did understand that Mr. Allen would have supervised access to his son, both in San Antonio as well as North Texas. Additionally, we do know that on the 22nd, we received a letter from Thomas Villalobos, an update letter regarding bond conditions. That letter also attached had the Center for Healthcare Services finding that they had met with Ronald Allen to complete an intake for mental health services and that he hadn't met criteria for qualifying mental health diagnoses at that time. The largest thing that matters the most to Mr. Allen and his family is that his GPS permit him to be monitored. That's fine if that's what the court desires, but he would like to be able to move freely about the state, to be able to see his son from time to time, attend his father's services, and help his mother maintain his father's properties. And so that is the primary thing. We totally agree with no contact with either Michael Ireland or Mark Medley. That's new to me, but he's fine not staying away from that man too.
Based upon the judge's notes that you presented to the court, those are people that are listed under the protective order. And there's a third person, it appears, well, there are two other people. It appears to be either this is Gallegos, and then they have Ramirez, and Ramirez is listed as the amicus attorney.
Okay, Judge, those are not, those are other litigants that were also in the judge's notes. Ms. Gallegos is actually here in the court, and she's the custody lawyer for Mr. Allen.
I'm just saying, the judge's notes that you gave me, they have these people listed underneath protective order.
This is the exact moment where Judge Boyd visibly starts getting uncomfortable, and you can tell this case just crossed into dangerous territory. The issue? The defendant's former custody attorney is listed directly in the protective order. That is not a small detail. That is a massive red flag. You can actually feel the air change in the room when she notices it. This clearly wasn't expected by anyone, not the defense, not the defendant, and definitely not the court. The defendant's body language shifts immediately. He looks nervous, guarded, almost caught off balance. And for good reason, because this isn't something you can casually explain away. If a former attorney is listed as a protected party, that raises some serious questions about behavior that goes way beyond a messy custody dispute. From the judge's perspective, this looks bad, really bad. Protective orders exist for safety, not technicalities. So now, Judge Boyd isn't just reviewing paperwork anymore. She's thinking about risk, credibility, and what she hasn't been told yet. Judges absolutely hate surprises, especially when those surprises involve potential threats or violations tied to people inside the legal system itself. And honestly, this feels like a sloppy mistake by the defense at best. How does something like this make it into the judge's notes without being caught ahead of time? This is basic diligence. Either the paperwork wasn't properly reviewed, or someone assumed it wouldn't matter. And in a case involving terroristic threats, that kind of oversight is unacceptable. From Judge Boyd's seat, this opens a whole new line of concern. If this detail slipped through, what else hasn't been fully explained? What context is missing? What behavior led to that attorney being listed in the first place? Because protective orders don't just randomly include people, especially not lawyers. You can see the pace of the hearing slow down right here. The judge becomes more deliberate. The questions get more pointed. This is the moment where a routine review turns into a deeper examination, and the defendant realizes this is no longer just about a plea. It's about trust and safety. So what do you guys think? Is this just a paperwork mistake that spiraled out of control? Or did Judge Boyd uncover something much bigger than what was originally presented? Drop your thoughts in the comments, because this moment changes everything.
I don't think that's accurate at all. I think that's being misread right now because...
I mean, that's the only way I can read it, and the reason why I'm saying that's the only way I can read it is because it lists Medley, it says protective order, and then indented right underneath it says M. Medley, which is the state has outside the agreement. They're asking for a no contact order with that person, with Charles Ireland. And then they have someone by the name of Gallegos and Ramirez.
Right.
And then right after it says that it has protective order, then right after it mentions those three names, then again, it says 2-year protective order granted as to, I believe that's the mother.
That's the mother's name. Yes, Mrs. Allen. Yes. But there is no protective order granted in that order regarding Mark Medley, regarding any of those people. The only one that has a protective order granted against is the mother of the child that we're talking about here. Ms. Gallegos is here and she hasn't asked for a protective order, and we know that the amicus doesn't have a protective order either.
Okay, so this is what I'm going to do. I've taken your plea, and if somebody can tender to the court whatever the orders are on the civil side, I'll review those, because those judges' notes that were handed to me appear that there's a no contact order. And I think you want to have those,
right? Exactly.
Know for sure whether it is or not, because otherwise you may be violating orders over there.
Absolutely. Black and white.
So what we're going to do is I've taken your plea. If you all are waiving PSI, I won't set it for a PSI. We'll just come back when I'm back. I'm going to be gone the first week of September because I have to go to a judicial conference, have to keep up my educational courses. And then the second week I have jury duty, and I can't have other people go to jury duty and sacrifice their work, but I'm not willing to do the same. So I have jury duty that week. So it'll have to be the third week in September, and that'll give everybody a chance, and perhaps a chance for you to speak with the state with regards to all the names that they have listed outside the agreement, because they have Medley listed as a no contact person too.
Well, and absolutely. And we understand that Mr. Medley called and asked for that kind of to be added to this order. That's my understanding from my discussions and my review of the state's file. But, I think the reason you see this line that says protective order plus merits is because that is what the topic of the entire, and what you're seeing here is actually the litigants that are, or the attorneys representing each of these litigants.
The best way to discover what that means is
Yes.
the judge.
I just have one request. We have services from my father September 5th, and I'm on the
Go to the
DBS.
services.
Yes, thank you.
Yes.
Absolutely.
But here's the thing about going to those services, and state, I've overstepped my bounds. Do you have any objections to his going to his father's services? All right. So what your attorney will need to do is I will print here a page with an order, and I will do the style, and you all need to write down your agreement.
Okay.
All right.
Absolutely. Thank you.
So you're welcome. So Ms. Ferguson,
Yeah.
when can we bring this back? And when it come back, I will need specifically what the judge is saying on the civil side,
Yes.
so that this could a little bit be in harmony.
Absolutely, I agree.
All right, the 16th, is that enough time for you counsel to have everything ready?
Yes, of course, Judge. And I want you to know that the civil court is waiting for the outcome of this case
All right.
in order to make their orders, and that's one of the reasons Ms. Gallegos is here.
All right, Ms. Gallegos, if we can go off the record, Ms. Gallegos, if you'll come up.
If you guys enjoy watching court hearings like this, make sure to hit that like button and subscribe so you don't miss any of these cases. And definitely let me know down in the comments if there's anything you want to improve on, break down deeper, or cover more of. I actually read all of them. With that said, let's get back into the hearing and see how this unfolds.
All right. Hello, how are you doing?
Yeah. Good for you.
Good seeing you.
Good to see you.
So anyway, it appears the documentation that I've received that has the judge's notes,
Mhm.
the way it's written, it appears that you're a part of the protective order. Medley is a part of the protective order. So if the court can get clarification from the judge
Okay.
on that side about who is really included in the protective order and what they are doing with the visitation, that will be greatly appreciated.
Okay, we have a conference call next week, and then we will be looking to get it entered. We are hoping to obviously do it as soon as possible, and we will try to meet your deadline of the 16th. And I'll let the other attorneys know. If not, do we need to send an email to Ms. Ferguson?
No, I mean, I'll just need that information before the 16th. So if you all can get the judge to if y'all want to, you can have the judge email me and
Okay.
say, this is who's a part of the protective order. Or if there's a document, can you pass me that sheet of paper? Or if there's a document that tells me this is the part of protective order, because the way the judge's notes are written, it's so,
Okay.
oh, you know what? I'm sorry. I need to add this.
So normally on the civil side, Mr. Medley is first because he's the petitioner. Margaret Gallegos, me, I represented the respondent, and then Anna Ramirez was the amicus.
Yeah, no,
and then it goes down.
The reason why I say that is because in the plea bargain agreement, even though it's outside their plea bargain agreement, Medley is mentioned. I'm sorry, can I have that printout one more time? So that's why I need clarification, because the way that's written in the judge's notes, as you can see, it has a title, protective order. Then it has a list of 3 people. Then underneath that list, then it comes back with a 2-year protective order. So it seems as though those are the people that he has a protective order against. So I would prefer that he know, I would prefer that I know, and probation knows.
So on here it says 2-year protective order granted as to Mrs. Al.
Yeah, but above it, it says protective order.
Okay.
So if you all will fill in the dates for him, please, and what you all have agreed on as far as his ability to go to his father's services. So that sheet of paper, if you can just put in the agreed times where he can travel for his father's services.
Okay, I'll do that now.
All right, and if you all will confirm that, and then we will come back. Norma, you said the 16th?
Yes, ma'am.
All right, so we'll come back on September 16th, and at that time, I will enter my order. And we're back on the record, Cindy. And counsel, it's the court's understanding you're waiving PSI and TAP evaluation.
I would.
All right, so thank you.
Thank you, Judge.
All right,
Thank you.
thank you.
Thank you so much. I appreciate it.
And thank you for dressing appropriately for.
Absolutely, absolutely.
All right, and you're not excused until you sign the reset form, okay?
Absolutely.
So this guy actually walks out today without being sentenced, which honestly feels wild considering the charge he's facing. But you could tell Judge Boyd was clearly not comfortable moving forward without getting clarification from the other court. And in a situation like this, that's really the only responsible move a judge can make. When a judge pauses a case like this, it's usually because something serious just came to light. A terroristic threat charge tied to an ongoing custody dispute is not minor by any stretch. And if that attorney was correctly listed in protective order, this situation could turn very bad for the defendant moving forward. The judge's reaction tells me this wasn't just some harmless paperwork mistake. The moment she noticed that detail, everything changed. And honestly, that information should have been double-checked and caught long before it ever landed on her desk. I really don't understand how something that important slipped through. Either way, this case is far from over, and I'm definitely interested in seeing how it plays out once the court gets full clarification. Let me know in the comments if you want to follow up when that happens. As always, thank you guys so much for watching. Make sure to like and subscribe, and I'll see you in the next one. Take care.